I thank the chairman. I want to thank all the witnesses. I have the privilege of representing Colorado in the Congress, and so I want to say to Mr. Romero, welcome to Washington, and thank you for being here. Mr. Gingrich, I wasn't planning on talking about impeachment, but I just have to spend a minute on it, given the statement you made just a minute ago. I think you said, if I'm not mistaken, you said the two impeachments against President Trump were repudiated in the Senate. Is that the right word you used? Yeah, okay. And would you describe the impeachment that you initiated against President Clinton 35 some odd years ago and the Senate's reaction to that impeachment in the same way?
Hey everyone, welcome back to the channel. Today I want to talk about a recent hearing featuring Representative Joe Neguse and former Speaker Newt Gingrich. This was a heated discussion focused on judicial power and impeachment, so grab a seat and let's dive in.
Well, it failed, which is part of why Jefferson thought impeachment was not a realistic possibility.
Well, I would just simply suggest to you that, because I served as an impeachment manager in the second impeachment trial against President Trump following the attack on our nation's capital. And in that impeachment, as you well know, of all the presidential impeachments, which I suspect you've studied, 7 Republican senators did something that no senators had done in the history of our republic, which is voted to convict a president of their own political party. So I think that is a far cry from repudiation. I understand that it didn't meet the constitutional threshold for success.
Actually,
of course,
President Johnson had the same experience in, I believe, 1868.
I will just, again, simply say to you that unlike the impeachment, no, one that's inaccurate, Republican senators, with respect to the impeachment trial of 1868 against President Johnson, that is not accurate. It's the first time in American history in which senators of an opposing political party voted to convict a president, but of their same party, but I digress. I want to talk to you about a phrase you used. I think this is accurate. You called it a judicial coup d'etat. Is that, am I right?
That's correct.
Okay. And you would describe, 14 federal judges appointed by a president of an opposing political party issuing nationwide injunctions against a president's executive orders as a judicial coup d'etat.
I would describe the wave of decisions in the last 7 weeks deliberately designed to slow down, unwind, and block the president as clearly an effort by a group of judges.
I hear you. What I'm asking you, again, I don't think I'm mischaracterizing your testimony. 14 federal judges, all of an opposing political party, that is to say, 14 federal judges appointed by a president of an opposing political party, issuing nationwide injunctions against the president's policies, in your view, would be a judicial coup d'etat.
It depends on how long the time was.
Sounds like it depends on the president, Mr. Gingrich, because the president I'm describing is President Biden.
I know.
During his tenure, 14 federal judges issued injunctions against policies that he pursued via executive order. How many of them were appointed by Republican presidents? Do you know?
No.
100%, all of them.
Well, you're making my case.
I'm making your case. What's fascinating, Mr. Gingrich, is I didn't hear much from you about judicial coup d'etats when President Biden's policies were being rejected by federal judges across the country. It is very convenient now, lo and behold, that you take great issue and you describe it as a judicial coup d'etat when I didn't hear these words 2 years ago.
Had the Judiciary Committee invited me in during the Biden administration, I would have been glad to say.
Well, I regret that Chairman Jordan.
I don't approve of.
I regret that Chairman Jordan didn't issue an invitation to you when, as Mr. Massey articulated, policy after policy, executive order after executive order issued by President Biden were being rejected by federal courts, subject to nationwide injunctions across the land. Apparently, you were just waiting to come testify in front of the committee to call that a judicial coup d'etat against President Biden. That's what it sounds like.
That's why I believe any kind of nationwide injunction should immediately go to the Supreme Court to be validated as a nationwide activity.
Well, I
don't believe district judges
I understand
have the authority.
that alternative. I understand that you've provided that particular alternative as something for this committee to consider. Your written testimony indicates far more significant and structural changes. You referenced the Judiciary Act of 1802 and this notion that the Congress can abolish district courts and the rest, and you seem to be suggesting those as remedies that we ought to consider. In any event, I just want to talk, I know I'll ask the chairman to indulge me since I know he's indulged other members. You have talked about, and I'll just read from an article here, there's a long tradition which has only been broken really starting in the late 1950s with this crazy idea that lawyers and judges are superior to the rest of us and they get to define everything, right?
That's correct.
And you're referencing what case?
Cooper versus Aaron.
Cooper versus Aaron. That case was a desegregation case, right?
Yeah, but that wasn't the point of it.
I understand, but this was a case in which the state of Arkansas was seeking the ability to not comply with Brown versus Board of Education in desegregating schools in Arkansas. It had nothing to do, by the way, Speaker Gingrich, with presidential power. It had to do with the supremacy of the Constitution and the ability of states to respect the Supreme Court's interpretation of the Constitution. There are a variety of cases long before Cooper in which the Supreme Court has opined on the constitutionality of a president's actions, Youngstown being a great example. It is convenient that for whatever reason you've landed on these 1950s desegregation cases as the inception, in your view, of the Supreme Court's tyranny, as you describe it, I suppose. I don't think that that's consistent with the values of the American people. It's the reason why Republican jurists, Michael Mukasey, a very distinguished federal jurist, as you know, has attacked your ideas in the past. I think you'd concede that. I yield back.
If I
Continued indulgence, I would
Just 1 second.
let the speaker finish.
All
his
I will
answer.
say is, the reference to that is from a book by a liberal lawyer who said specifically that it's Cooper versus Aaron, where, with no reference to the case, the Supreme Court decides to issue a statement that it is clear that we are supreme. And they're not talking about we're supreme over Arkansas. We are the supreme deciders. And that is explicitly false and historically wrong. And it's what Jefferson was so furious about in 1800 because he did not believe judges had the ability to overrule the American people.
First off, let's set the stage. Representative Neguse represents Colorado in Congress and took the opportunity to challenge Gingrich on impeachment and what he termed as a judicial coup d'etat. Now, as a proud patriot, I want to address some of the points made during this hearing. Neguse kicked things off by discussing the impeachments of President Trump. He argued that the Senate's actions were not a repudiation, but let's get real here. The fact that 7 Republican senators voted to convict Trump was a huge disappointment to many of us. This was a political maneuver that undermined the will of the voters who elected him, and it set a dangerous precedent for future impeachments. Impeachment should never be a tool for political revenge. When Gingrich reminded everyone that his impeachment of President Clinton also failed, he highlighted a critical point. Impeachment is not a decision to be taken lightly. It should be reserved for clear violations of the law, not for policy disagreements. Neguse, however, seemed to downplay this historical context, which is troubling. Now let's talk about this so-called judicial coup d'etat. Neguse was quick to point out that 14 federal judges, all appointed by Republican presidents, issued injunctions against Biden's executive orders. While he framed this as a problem, I see it differently. This is a necessary check on presidential power. When the executive branch overreaches, it's the duty of the judiciary to step in. Neguse argues that we didn't hear him call this a coup d'etat when judges blocked Biden's policies. Well, maybe that's because many of us were relieved to see the judiciary doing its job. We should be applauding judges for standing up against overreach, not disparaging them. Neguse suggested that nationwide injunctions should go straight to the Supreme Court. I agree that there needs to be a clearer process in place, but let's not forget that these judges are acting to protect the Constitution. They are ensuring that the executive branch doesn't steamroll over state rights and individual liberties. Neguse attempted to paint Gingrich's historical references as flawed, particularly regarding Cooper versus Aaron. But this case is crucial because it reaffirmed the supremacy of the Constitution. If we ignore these decisions, we risk allowing states to flout federal law, which could lead to chaos. It's important to uphold the rule of law, even if it doesn't always align with our party's agenda. Neguse's comments about judicial power being superior to the people's voice are a classic liberal talking point. This isn't about whether judges can decide everything. It's about ensuring that our rights are protected from an overreaching government. When the left talks about judicial tyranny, they often do so because they disagree with the ruling, not because they care about the Constitution. We need judges who adhere to the Constitution and uphold the values that this country was built upon. The left has been packing the courts with liberal judges who legislate from the bench. We can't let that happen. It's time for conservatives to rally behind judicial nominees who respect the original intent of the Constitution. As patriots, we must remain vigilant. The left is relentless in their pursuit of power, and they'll use every tool at their disposal, including manipulation of the judiciary. We must advocate for reforms that ensure judges are held accountable and that they operate within the confines of the Constitution. In conclusion, this hearing was a microcosm of the larger battle we're facing in America today. It's about judicial overreach, the rule of law, and the proper checks and balances that our founders envisioned. Let's continue to fight for our rights, uphold the Constitution, and ensure that our voices are heard loud and clear. If you enjoyed this reaction, don't forget to like, subscribe, and hit that notification bell for more content. Stay strong, stay informed, and keep fighting the good fight. Until next time, God bless America.